Top 5 mistakes I see complainants make when it comes to remedies and damages. Their civil action discrimination cases and their EEO discrimination cases. Number 1, when you attribute the pain and the suffering to the stress of litigation. The defense will try to trick you during a deposition or during a hearing and say, isn't it true that the pain and suffering you're experiencing is because of the stress of the litigation? And of course, you may be tempted to say, yes, of course. But they know the stress of litigation is not recoverable. It's kind of a defense to damages. They could say, see, judge, this person's pain and suffering is because they were just stressed about the litigation. So the solution to that is to say, well, every time I think about the litigation, I think about the facts. I think about the discrimination that I incurred. I think about the actual events. Of course, I'm not going to tell you what to say, but if the shoe fits, that's the solution. Number 2, not documenting your out-of-pocket pain and suffering damages, pecuniary damages. At hard costs require hard documentation. If you don't produce that during the discovery period, then the other side could have an argument for excluding that as evidence. Number 3, not really understanding the categories of damages and what you can recover. Now listen, you don't have to be an attorney to understand this. I have a free guide, for example. Whenever there's an area of law, that means that there are limits within that area of law. And so you should understand what kind of categories of damages and remedies you can get so you know what's reasonable and what's not reasonable. So the fix for that is to at least do a little bit of research, look at a guide like mine, or consult with an attorney so you at least know the parameters that you're playing in. Number 4, attributing your damages to major life hardships. Agency counsel or defense counsel will try to trick you again at a deposition or a hearing and will try to say, well, isn't it true you went through a bankruptcy or a divorce or a death in the family? What they will try to argue is that these are the reasons that you are enduring pain and suffering. When that comes up, there's a few ways around that. For example, you can say that, well, yeah, I endured these things. And yes, I did suffer from these things if the shoe fits. But having been discriminated against sure did not help. It sure did make these things worse. This is a fact by fact thing, and you should consult with an attorney as the best way to approach that. Opposing counsel will be trying to figure out other causes of your damages. Number 5, the 5th mistake that I see is that a medical provider or a therapist does not actually connect the discrimination to your damages. Look, not every part of discrimination is going to result in some kind of medical outcome. But if you are going to claim that, then you do need to show some kind of causation. You need to connect it up. Your therapist, your medical provider, connect the dots. Should be putting that in the records for you. Finally, as a 6th and maybe a bonus, people will sometimes make the mistake of not explaining that their pre-existing conditions were exacerbated by discrimination. See, agency defense or defense counsel will try to say, well, you had pre-existing conditions and it had nothing to do with us. If the shoe fits, you want to say the discrimination and the wrongful actions caused an exacerbation or a worsening of your conditions. Of course, if the shoe fits. What's factual? These are my top tips that I see and some of the mistakes that I see and some of the solutions. Of course, your goal is to try to maximize your recovery and get justice.